right, good morning. I'd like to call the regularly scheduled Planning Commission for August 2013. I'm sorry, August 13, 2020 to order. If you would, please rise for the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Thank you. All right. So, let's see. It's a little bit different when you don't have everything digital. Ms. Lydar, have there been any changes to the agenda?
Good morning. Yes, there are minutes for approval for June 11, June 9, and July 24th, and a revised traffic easement statement for item number 4, C2002, Nora and Aaron LLC.
Very good. Thank you. Ms. Schenk, is there anything from the County Attorney's Office?
No changes, Mr. Chair.
Thank you very much. All right, with that, we'll go ahead and consider, I'm sorry, the agenda doesn't state what the dates are for the minutes. Could you please state those again?
Yes, the minutes are June 11, 2020, July 9, 2020, and July 24, 2020.
July 9th and July 24th. Thank you. Ms. Schenk, can we do all of those at one time, or do we need to break them out?
You can approve the minutes if you read a motion with all of them in there.
Okay. All right. Regarding the minutes for June 9th, 2020, June 11th, 2020, July 9th, 2020, and July 24th, 2020. Have there been any corrections, revisions identified? And if not, the chair will consider a motion.
So moved, Chair.
So moved.
Second.
Second. Any discussion? Thank you. The chair is going to call the matter to vote. All those in favor say aye.
Aye.
Opposed, like sign. Chair votes aye. Motion passes 5-0 with Mr. Rutledge.
Yes.
Oh, I'm sorry. I didn't know you were with us. Good morning, Mr. Rutledge.
Gave me, Bill.
Thank you. Again, amend that to motion passes 6-0 with Mr. Ron being absent. Thank you. All right. We're going to move on to citizen comments. Actually, before that, let's just discuss some of the social distancing protocols. If you could maintain distance of more than 6 feet separation, of course, wash your hands, cover your mouth if you cough or sneeze. When we open this up for public comment, there's a microphone behind the bulletproof shield there, and after each speaker, we're going to have staff come up and sanitize the microphone and the podium there. So if you could just please be patient as they wipe it down and allow them to do that. Just queue up behind the microphone, please. All right. Again, the next item on the agenda is citizen comments, and this is an opportunity for anybody in the audience who wishes to come forward and make a statement regarding anything that is not on today's agenda. If you have a comment or concern regarding something that is on the agenda, you'll have an opportunity when that application is heard. But again, we open it up for anything that is not on today's agenda. Does anybody wish to come forward and make a statement or comment? Okay. Seeing no one come forward, we're going to go ahead and close the citizen comment portion of the hearing, and we're going to move on to the advertised public hearings. We have 2 items. The first item is a amendment to the Land Development Code, and I believe it's being presented by Mr. Clegg. Is that correct?
That is correct, sir.
And Mr. Clegg, we would like to open items 2 and 3 separately.
Separately, yes, please.
So
Two
we'll
separate
open
public hearings.
We'll open item 2 presentation, vote, and then,
Then proceed to item 3.
okay, very good, thank you.
You're very welcome. Good morning, Mr. Chairman,
Good
members
morning.
of the Planning Commission. For the record, I am Chief Assistant County Attorney Bill Clegg. These two items are legislative land development code amendments, each being presented by the County Attorney's Office and each driven by court decisions involving provisions of the LDC. And that's why they're coming to you from us rather than staff. It's been quite some time since our office has had to do that. But we have done it in the past, but I'm not sure that the last time we did it, any of you were on the Planning Commission, quite honestly. So starting with, well, I guess before I move into item 2, I should say, when the County Attorney's Office brings LDC amendments forward, it's a little different than the way staff does it. We do that where we've identified in a court case an issue that we think needs to be modified in the code in order to render it legally defensible. We don't come here with LDC amendments to advocate policy changes. So we do the minimum that needs to be done to address a legal issue that's come up in court. If the board or staff wants to go beyond that, then at that point, we would hand it off to them. So I just want to make sure the Planning Commission understands why it's coming to you from us and what's driving it. You had a question, sir?
No, I was just going to say, for the record, this is item number 2, LDCT 20-05 ordinance 20-33 land development code amendment, conservation easements. So,
Okay, yeah, I'm about to go
record.
into item 2, but
Yeah.
these are sort of,
It's for the board.
proceeding remarks just to make sure you understand with both items why they're coming to you. So,
Thank you.
and we should probably read it into the record. If Rosina could do that, please, now that we are ready to proceed to item 2.
Yes, item number 2, LDCT 20-05, Ordinance 2033, Land Development Code Amendment, Conservation Easement, PLN 2005-0057, an ordinance of the Board of County Commissioners of Manatee County, Florida, regarding land development, providing for purpose and intent, providing findings, amending section 706.8.b of the Land Development Code to clarify the requirement for post-development conservation easement for wetlands and wetland buffers, providing for codification, providing for applicability, providing for severability, and providing an effective date. This is a legislative case, and Mr. Clay, Chief Assistant County Attorney, going to present to you. Also, and citizen comments has been entered into the records and has been distributed to all the commissioners.
All right.
Thank
so
you.
now that
Thank
we're
you.
ready to go directly into the details of item 2, this is an ordinance amending section 706.8b of the Land Development Code, which concerns the requirement to provide the county with conservation easements over wetlands and wetland buffers. It's part of a larger section, section 706, that is pretty lengthy and implements the county's comprehensive plan requirements for wetlands protection. So that larger section includes provisions requiring avoidance and minimization of wetland impacts, mitigation of wetlands, and also restrictions post-development once a project is complete in order to protect the wetlands and wetland buffers that remain after the project has been developed. This is not new material to the Planning Commission. You hear about these issues all the time, and this is the section of code that governs them. Section 706.8 includes provisions requiring post-development conservation easements. And again, they apply to all remaining wetlands and the buffers around those wetlands. The first provision is a section 706.8a, which applies to any wetland area that is created or restored as mitigation for an impact. And that section is not affected by this amendment. This amendment deals strictly with 706.8b, and that section applies to all wetlands and wetland buffers within a project, regardless of whether they are associated with wetland mitigation. It is an across-the-board, automatic conservation easement, if you will, that has to be dedicated to the county in any development project at the conclusion of that project, covering all wetlands and wetland buffers. It's been in the code for many, many years, since the 90s, but a few years ago, the county did receive a lawsuit claiming that because this requirement applies across the board regardless of the impacts within a project, that it violates the constitutional standards for exactions of interest in land from developers. Basically, the Kuntz requirements of a nexus and proportionality between an impact and that which you are requiring a developer to give to the government. So this was litigated pretty intensively by the county attorney's office, and initially, the trial court agreed with the plaintiffs that this provision violated the Kuntz standard. The county appealed that, and we successfully got that trial court decision overturned, but on a matter that was unrelated to the substance of the requirement. It was basically a statute of limitations issue. But since that original trial court judgment, the county has not been requiring developers to comply with this provision. For quite some time now, we have not been requiring these automatic across-the-board conservation easements because of the trial court judgment. So because those substantive concerns remain, it is the advice of the county attorney's office that this section of code should be amended as provided in your agenda package. Basically what we are doing here is we are incorporating the Kuntz standard into the conservation easement requirement so that staff can only require those conservation easements where there is a rational nexus and rough proportionality. We did something similar with our right-of-way dedication requirements. I want to say we did that 4 or 5 years ago. Basically the same concept was incorporated into that section of the code, and that's what we're recommending here. I do want to say that even without conservation easements over wetlands and wetland buffers, the provisions of the code and the comprehensive plan that restrict development or impacts to those areas remain in place. The conservation easement has functioned as a sort of a backstop, additional protection over those areas, but you still have to go through the same process that you see all the time in front of the Planning Commission of getting the approval of the county if you're going to impact a wetland or wetland buffer, regardless of whether or not there's a conservation easement. So for that reason, we do feel that it doesn't create a concern about consistency with the comprehensive plan. We're still protecting those areas. We're simply not getting conservation easements over them unless we meet the Kuntz standard, which we have to do under the constitutional case law. So that really concludes my remarks, Mr. Chairman. I do want to point out, Board Records was kind enough to bring to my attention that there is a Scrivener's error in the recommended motion. It refers to the Code of Ordinances. It should refer to the Land Development Code. But other than that, we would ask for the recommendation of the Planning Commission to the Board, finding the ordinance consistent with the comprehensive plan, and I'll be happy to answer any questions.
Very good. Thank you, Mr. Clegg. I do have a couple questions. First, the individualized determination, is that still the same process that the county's been performing prior to the suggested amendment of this text?
Well, that's a term that comes right from the case law. Mm-hmm. And there isn't a lot of law out there about what it means. In other words, that hasn't been litigated very much. But in our view, going through a quasi-judicial hearing and putting the information in the record to justify for that specific project why it's appropriate to require a conservation easement would satisfy that requirement.
Mm-hmm. And then I guess kind of hand in hand, the proportionality that's performed, the determination of the proportionality is performed by the county, and those standards are still consistent with the Land Development Code and the rules and regulations that were previously adopted.
They would have to be, and we would rely on the county's environmental review staff to make that analysis.
And with regard to the easement itself, is the easement always going to be granted in favor of Manatee County? Are there other entities that can receive the rights associated with the conservation easement?
The code requires that it be dedicated or conveyed to the county. It is not unusual to see developers also convey a similar easement to an environmental advocacy organization. We did that, for example, in the Braden River Preserve case, and I think we did it in Robinson and a couple of others. I think the phosphate companies have done that a couple of times. But the code requires one to be conveyed to the public, and quite honestly, that is what triggers the Kuntz analysis.
Okay.
That's exactly why it's an issue for us.
Right. And then the language of the easement, I know having had to work on projects that included stuff like this, I've experienced where there are multiple agencies that require the same as you described.
Correct. Yes.
And is the county flexible enough to amend their easement requirements to accommodate, say, the Army Corps or the Water Management District?
It depends, is the answer to that. We have a standard form. We're still utilizing that form under 706-8A for easements that are required under mitigation areas. And that form has a little more detail in it and is different than the standard forms of DEP and the Water Management District. I'm honestly not sure about the Corps. I don't think I've ever reviewed a Corps conservation easement. I'm sure they're out there, but I've just never had the opportunity to look at one. There is room to be flexible as long as it's not reducing the protections that the county staff feels need to be there. For example, many of them don't address mowing and clearing to the extent that ours does. And that's been an issue for our staff in conservation areas in the past, that it hasn't been as big an issue for the Corps and the Water Management District and DEP.
And then my last question,
Another one, I'm sorry to interrupt, another one is cattle grazing. You know, they're like in the phosphate conservation areas, the state doesn't really have an issue with the cattle coming in, but sometimes our staff does. So those are some of the things I've experienced where there's been a little bit of tension between the county and the state agencies.
And another question I have is, I know at times there are conservation easements that are required on properties that aren't, habitats that are not necessarily wetlands. Does this, do these rules and regulations associated with conservation easements also apply to those areas?
This particular code provision addresses wetlands and wetland buffers only, because it implements the conservation element of the comprehensive plan and the provisions within it dealing with wetlands. So staff would have to be looking to other areas of the code or the comprehensive plan if they're going to require something outside of the wetland preservation activities or the avoidance and minimization protections.
Okay.
There are other instances where they do that, I recognize, but not under this particular code provision.
Okay. I'm just trying to make sure I understand how this would be implemented and the effect it has on the current process and moving forward. So thank you very much for the explanations.
You're very welcome.
Any additional questions for Mr. Clegg? Yes, sir. Okay. We're going to
go. Bill?
Who said that?
Paul Rutledge.
Oh, Paul. Yes, Mr. Rutledge.
I just had an experience with this, and I'd just like to ask, Counselor, is there any loss of control or prerogative with the modification of this? In other words, does this diminish the obligations, or does this permit future modifications to the conditions or the requirements that are put in place because of the way this is structured?
Well, I got the first part of your question. I'm not sure if I understand exactly what you mean in the second part. I would say that if staff had its preference, they'd rather have conservation easements over anything they're trying to protect within a project.
Sure.
That is why the code was written the way it was some years ago. The courts are not going to let us do that. Even though we've survived a facial challenge to this ordinance based on a statute of limitations defense, we do expect, in fact, we've already received what we call an as-applied challenge, where they're saying under their specific circumstances and their project, this results in an unconstitutional exaction. And we're going to have to continue to deal with that. And right now we're not enforcing this provision because of that. So we need to make this modification. This is coming to the board as the recommendation of the office as our legal advice. So does it diminish the protections that we have over those areas? Yeah, it does. But we also do have confidence in our our comprehensive plan wetlands protections, which have been upheld by the courts as constitutional, as still being fully in effect and things that we can rely on and enforce where we need to. Does that answer your question, sir?
Yes, sir, it does. And I had one other. Are other agencies like EPA, Army Corps, or Water Management using some other vehicle that's supportable as a way of defending this that may be more far-reaching?
Probably not. It's very difficult to gauge what's happening at the state level right now. And I don't claim to be an expert in it. Maybe staff would be better suited to respond to that than I would. But it seems to vary from water management district to water management district. Yeah. They don't have to follow one another's practices. They just have to follow the same overall statutory framework. And I'm not sure where DEP is right now because we had a change in the executive leadership in the state, and that has resulted in some very significant changes in how DEP is approaching these things, but I honestly am not sure where they are. I think if we were going to look at those things, that would be something staff would drive. Going back to what I said at the outset, that's not something that the county attorney's office would bring to you. Again, this is driven by our experiences in defending the county's code provisions in court. But staff has the prerogative to do that if they think that it's needed.
And not that it's relevant to this particular item, but in other municipalities, I've had incidences where there have been 3 requirements for conservation easements, and I think the Army Corps and the Water Management deferred to the county in that particular case. As long as there was a document that secured the easement over the property, they were okay with it. So there seems to be some flexibility with regard to the agencies.
Quite honestly, I think ours is more restrictive than theirs, and so that's probably why they did that, because they felt like they could rely on ours.
Mm-hmm. Very good. Very good. Thank you. Again, any additional questions for Mr. Clegg? All right, hearing none, we're going to go ahead and open this up for public comment. Is there anybody in the audience who wishes to come forward and make a comment or ask a question regarding this matter? Anyone at all? Okay, seeing no one come forward, we're going to close the public comment portion of the hearing for this application. And Mr. Clegg, is there anything additional you'd like to add?
No, sir.
Okay, the chair is going to consider a motion on item number 2. What's the pleasure of the board or the commission?
Mr. Chair.
Mr. DeLesline.
I move to recommend adoption of ordinance 20-33, amending the Manatee County Code of Land Development Code as recommended by staff.
Okay, very good. We have a motion. Is there a second? Mr. Ross, second. Any discussion? All right, we're going to call the matter to vote. All those in favor say aye.
Aye.
Opposed, like sign. Hearing none. Mr. Rutledge, what was your vote, please?
Aye.
Aye, very good. I think from now on I'm going to do a little roll call so we get everybody on the record. So, all right, so we have 6 in favor, none opposed. Chair votes aye, so the motion passes 6-0 with Mr. Ron being absent. Thank you very much. So that
Yes.
brings us to item number 3. And Ms. Lidar, can you please read item number 3 into the record?
Yes, Land Development Code, LDCT, Land Development Code Text Amendment 2006, Ordinance 2034, Land Development Code Amendment, Requirement for Enforcement, Appeals, Schedule of Uses. This is a legislative case, and Mr. William Clay, Chief Assistant County Attorney, going to present the case. An ordinance of the Board of County Commissioners of Manatee County, Florida, regarding land development, providing for purpose and intent, providing findings, amending sections 1063.8, 370, and 402.5 of the Land Development Code to clarify the requirement for enforcement, appeals of administrative decisions, and the schedule of uses for planned development zoning districts, providing for codification, providing for applicability, providing for severability, and providing an effective date.
Very good. Thank you. Mr. Clegg.
Mr. Chair, like the last one, this one also has a Scrivener's error in the recommended motion. The reference to Code of Ordinances should be a reference to Land Development Code. This one provides for 3 surgical amendments to the code. Again, they are driven by recent experiences of the office in defending code provisions or decisions under those code provisions in court. The first two are very quick and easy to explain, and they deal more with procedural requirements that the Planning Commission, quite honestly, doesn't see. The first being the amendment to 106.3A, which is clarifying that the provisions of the code that allow for parties to seek injunctive relief under the code where the code's being violated do not allow those third parties to file lawsuits against the county trying to force the county to enforce the code. The court, when this came up in court, agreed with us on this. We just want to make sure it's very, very clear. It's common in codes around the state that they have provisions that allow someone to seek injunctive relief. In other words, if I own a house and somebody next door to me in a residential neighborhood is operating a light industrial use in their backyard, I have recourse to go to the court and seek an injunction against that individual. What I don't have is recourse to go to court and seek an injunction against the county, forcing the county to enforce the code against that individual. And that's consistent with the longstanding case law in the state of Florida. So we're just looking to clarify that so that people understand when they read the code, that's how it works. The second deals with who may appeal an administrative decision. We had a dispute as to whether or not a third party who objected to an administrative approval had the right to appeal that decision to the Board of County Commissioners. We want to make it clear that they do, because we want them to go through that process before they file a lawsuit against the county regarding, or against that individual regarding an alleged violation of the code. The third takes a little more explanation, because this deals with allowed uses under our schedules of uses for both straight zoning districts and planned development districts. It's very common in Euclidean zoning, going all the way back to the 20s, that zoning codes contain what they call a catch-all provision, which is language in the code that says that if you come to the government with a use that's not specifically addressed in the code, usually because it's new, then you're not necessarily prohibited from having that use on your property. The staff, the local government, has the ability to look at that use and see if it is similar enough to another use that it can be allowed in those zoning districts where that other use is allowed. The easiest way to understand this is hot tubs. Okay, some of us are old enough to remember, and I'm dating myself here, but when hot tubs were a new thing in the 1980s. Today, you have language in your codes about hot tubs. But when they came out and they were all the rage and people were having questionable parties with hot tubs, the codes did not have language addressing those, but what they did have was language addressing above ground pools. And so the local governments, while they were going through the process of amending their codes to deal with them, didn't have to prohibit everybody in the world from having a hot tub. If they didn't have that catch-all provision, nobody would have been allowed to have one. So these are needed in your code to deal with a changing world. They provide some flexibility in the code to deal with new uses that haven't been anticipated. Otherwise, they can be regarded as prohibited and locks you into only those things that are allowed in the code can ever be allowed on anyone's property. The difficulty that we have is that we have a catch-all provision that applies throughout the code. We have another one that is stated in our straight zoning district, but it's not repeated in our planned development districts. And so a court, to the chagrin of the county staff and the county attorney's office, concluded that because it's not stated in both places, we cannot use the broader catch-all provision in planned development. So any use that's not specifically allowed in your planned development zoning code is prohibited. That is not consistent with how staff has been implementing the code for a good many years. So the purpose of this amendment is to clarify that. Rather than arguing it with the court, the best thing to do is come back and fix the code. We own our code, and it's our job to keep it up to date so that that catch-all language applies in both planned development and straight zoning districts. Does that make sense? I mean, I know it's a little bit more complicated than some of the other issues, but
No, I think we had experience with that recently at off of State Road 70.
all right. Well, that concludes my remarks, and once again, we would ask for a recommendation of the Planning Commission that it's consistent with the comprehensive plan.
Very good. And I do have a question regarding 106.3A, the remedies, enforcement, the remedies. With regard to the parties that could, I don't know if the proper term, but seek relief, if you had an example where you had a developer who did something and then there was a subsequent HOA or CDD, do those rights to seek relief, do those continue to?
Mr. Chairman, that's a very fact-driven question, and so I will provide you with the, sort of dodgy lawyer answer, which is it depends, because what happens in those cases is there's always an argument about who has standing to seek recourse in the courts. They always raise it.
Okay.
And the judge always has to decide. And it's partly driven by the law, but partly driven by the factual scenarios.
So with regard to that
So I
response,
couldn't answer that.
With regard to your response, I can take that and interpret it for myself, and it's going to be dependent on the situation.
Yeah.
What are the facts? So
Always,
and
every time.
Completely understand that because there are a lot of nuances that weren't covered in my question.
I would say 80% of the time that our office has to litigate things like that, standing is an issue. And maybe the litigators would say more than that. I mean, it's a lot. It's very commonly raised.
Okay. All right. That's completely understandable. So, all right. Any questions for Mr. Clegg on this item?
Yes, sir.
Mr. Rutledge? All right.
No, sir, none.
Okay, thank you. All right, thank you very much. We're going to go ahead and open this up for public comment. Is there anybody who wishes to come forward and make a statement or ask a question regarding this application? Anyone at all? Okay, seeing no one come forward, we're going to close public comment. And if there are no additional remarks, Mr. Clerk?
No, sir.
Okay, and nothing from the planning commissioners, we're going to go ahead and consider a motion.
Mr. Chair,
Mr. DeLesline.
I move to recommend adoption of ordinance 2034, amending the Manatee County Land Development Code as recommended by staff.
Thank you. We have a motion. Is there a second?
Second.
Sorry, who was that? Mr. Smock, second. All right, any additional discussion? All right.
Mr. Chairman, does that include the language change Code of Ordinances to LDC?
Yes, ma'am.
Thank you.
Mr. DeLesline acknowledged that, and the second also acknowledges the change in language. So, all right, we're going to call the motion going to call the motion a vote, and I'm going to do a roll call. So, Mr. Roth? Aye. Mr. Smock?
Aye.
Mr. Heap?
Aye.
Mr. DeLesline?
Aye.
Mr. Rutledge?
Aye.
And chair votes aye. Motion passes 6-0. Thank you.
Thank you all very much.
All right, that brings us to item number 4 in our packet. Ms. Leiter. Yes, ma'am.
Item number 4, C-2002, Nora and Aaron LLC, PLN 2002-0010, a rezone of approximately 36.3 acres, generally located at 1300 49th Street East, Palmetto, and commonly known as Symphony Lakes, from residential single-family mobile home district 620 units per acre, RSMH6, to the residential multifamily district 9 dwelling units per acre, RMF9 zoning district. The case is a quasi-judicial case. Mr. James Rigo, principal planner, is the case manager, and representing the applicant here is Mr. John Foley.
Very good. And this matter is a legislative matter?
No, it's a quasi-judicial.
I'm sorry, quasi-judicial. This is a quasi-judicial matter. I was looking at the wrong one. As is item number 5. So if anybody intends to speak on item number 4 or item number 5, please rise to be sworn in. If you don't do it now, you'll have to do it before you speak. So please rise.
Do you swear or affirm that the factual statements and factual representations which you are about to present to the Planning Commission will be truthful and accurate? Thank you.
Very good, thank you. Morning, Mr. Foley. You wish to present your application?
My name's John Foley. Can you hear me okay? Good. I'm with Foley Cleric, civil engineering firm in town. We are happy with the staff report, and at this time would not provide any additional presentation unless needed.
Can you just give a brief description of your application for the benefit of the folks?
Yes, over the last 25 years, my office has done two developments on this piece of property, as discussed in the staff report. Neither came to fruition. The biggest issue being the lack of sewer service in the area. The county has sewer to the east about a mile away. County has sewer to the west at US 41, but there's a railroad crossing involved. So basically, we've had several meetings with county utility staff to discuss where we would need to get to tie into the county utility system. Cost to do that is approximately $700,000. With those type numbers, the zoning that's currently out there just doesn't generate the lot yield needed to make those numbers work. So I have a client who has been looking at the piece of property for the past year and a half. We have had, as I said, several discussions with the county about what we would need to do to make it developable and connect the county sewer. And we're here to request this zoning change to give us the ability to move forward.
Very good. And again, this is straight zoning, not a PD type zoning?
Correct.
So, okay, very good. All right, thank you very much. Any questions for the applicant?
Yes, sir.
Very good. Thank you. All right, who do we have for staff? Mr. Rigo. Good morning. How are you?
Good morning, Commissioners. My name is Jim Rigo. I'm a Principal Planner with Building Development Services. I have been sworn. I'm here to present the Nora and Aaron LLC rezone. It carries the name, as John mentioned, Symphony Lakes. Unfortunately, unsuccessful projects over the last 25 years, and he stated very clearly why that's the case. Although we can't consider those shortcomings in the sanitary and any utilities for the rezone, we feel like our recommendation here for that rezone, we have found a case to allow this to go forward. Second slide, please. This shows the location. We're at 1300 49th Street East in Palmetto. The site is shown bordered to the south, Experimental Farm Road, the south of US 41, and we are along the eastern edge of the rail corridor running north and south. Next slide. This pans back a little bit, gives you an idea of where we are in the area. It shows some of the residential areas off to the east. There is one planned development, Avignon, that's been approved within the last 15 years. The other residential developments are in the RSF 4.5 zoning category. Next slide. John talked a little bit about the history. I'll go over it. The property was rezoned in January of '85 from A1 to R4B. This was the mobile home residential in the old code. It was a 7 dwelling unit per acre mobile home classification. It was converted to RSMH6 with the adoption of the new code in 1990. Our records show a preliminary site plan was submitted for Sunnybrook Park, mobile home park, in December of '94, showing 185 lots. That development entered the construction process but was never completed. Final site plan, construction plan for Symphony Lakes was submitted in March of '96, and another final site plan, construction plan for 168 lots was applied for in October of 2000, but was not approved or constructed. Next slide, please. A future land use category, the site has a future land use of Res 9, residential 9 units per acre max, which is consistent with the proposed zoning classification. Res 9 was established to provide primarily medium-density residential and high-density clustered residential development with support uses such as neighborhood commercial, office, semi-public, recreational, and school uses. So this was a needed transition between the low to medium residential to the east and the ROR IL that you see off to the west. Next slide. The current zoning classification, residential single-family mobile home. It's intended to accommodate mobile home parks and subdivisions in a suburban residential environment. The uses for this are very limited. They're limited to mobile home use and very few other residential support uses, and that's the reason, again, for the request of this rezone. Next slide. So the request today is to rezone the 36.3 acre parcel to RMF 9. The purpose of these districts is to provide areas for multifamily dwelling units at a medium to high density at appropriate locations. In addition, the districts are intended to accommodate complementary residential support uses and limited non-residential uses. It's a straight rezone, so there's no plan associated with the request. Some general site characteristics. It's 36.3 acres. It's vacant. The site is serviced by water but no sewer, and it's located in the next flood zone, although there are some flooding issues that I think Tom may go over later, and we're in the coastal planning area. Next slide. So discussing the coastal planning area, the parcel is on the eastern edge of the coastal evacuation zone. It's in the sea level evacuation. What's important to note is the comprehensive plan policy prohibits mobile home development in the CPA. Density bonuses for affordable housing are not allowable in the CPA or CEA under the Res 9 comp plan policy. Additional performance standards are required for infrastructure. Next slide, please. This is an overhead view of the site. As you can see, it's vacant. The surrounding land uses, we can work our way counterclockwise starting at State Road 41, or US 41, I'm sorry. Opposite of the railroad, we have heavy commercial, we have light manufacturing, and planned development, industrial. We have a mix there. And as you move up Experimental Farm Road, you move into the residential. There is a A1 property, 13 acres there off to the left before you meet our site. And as you move to the north, and to the east and north, you run into more A1 and residential 4.5 unit per acre zoning. Next slide. Here are some views of around the site as we drive over the overpass at the rail corridor. This is looking down at the site. You can see it's fairly overgrown. It was active agriculture per our maps until I'd say the late 80s. It's pretty much grown in since then. Next slide. So if you were to drive south on 41 and start heading east down Experimental Farm Road, this is what you see for the planned development industrial before you head into the residential area. There's the rail corridor there. You see on the left there, Buckeye Gas Products. Next slide. Heading further to the east, on the left is a suburban agriculture lot. There's one dwelling on that 13-acre lot. And as you continue to move east towards the subject property, you have other lots that range anywhere from a half to a third of an acre. Next slide. We approach the site. There's the subject property. Next. If you look off to the right, there's the FP&L substation property. A large drainage ditch along the road there. Next, please. And as you pass the property, you get into some more residential lots. They're essentially the minimum size to accommodate a septic system. If you were to look in your rearview mirror, here's the residential behind you and the subject site off to the north. Again, these lots range from anywhere to 3 to a third of an acre. The last south frontage shows the property again. So I'll bring you back to the next slide, which is the surrounding land uses, and you notice the spout or panhandle off to the Canal Road. This does have about a 50-foot frontage out that way. At one time, one of the plans did show access out to Canal Road for Symphony Lakes. And the next slide shows that subject property. There's some friendly encroachment due to some maintenance by the neighbors to the south and the church to the north. As you get further into the site, there's a stand of trees that provides a buffer between the two. Next, please. The last surrounding residential we'll take a look at, it's Woodland Estates. It's a platted subdivision just off to the east, and you can see the property through the stand of oak trees. These lots are generally an acre to a third of an acre. Next slide. The positive aspects of this rezone would allow for a larger variety of housing types than residential single-family mobile home, which is generally restricted to mobile homes. RMF 9 allows for attached multifamily dwellings, which will make the density potential for the parcel more consistent with the future land use designation of Res 9. And we believe the higher density housing is a desired transition between the existing residential to the south and east and the commercial industrial off to the west. It removes mobile home zoning from the coastal planning area, which is mandated by the comp plan. It provides potential for a much needed workforce housing stock. The potential density may support the introduction of the sanitary sewer that Mr. Foley talked about, and it limits the potential commercial or industrial expansion eastward. Next, please. The negatives, it adjoins the RSF 4.5 single-family residential classification to the east, and it introduces multifamily to an area not currently having this land use. So mitigating these negative aspects would be to require buffering and setbacks designed to mitigate any possible negative impacts between the potential multifamily development at the site and the existing single-family residential homes nearby. Although there's no plan provided with this zone proposal, any of the allowable land uses available under RMF 9 could be designed to contribute to a denser, more centrally clustered development, which could provide better buffering to the surrounding properties. And based on the accepted traffic impact summary, it appears the adjacent segments of US 41, Canal Road, and 49th Street East will have sufficient capacity for the proposed project. Next, please. So in conclusion, staff feels that the zoning amendment is consistent with the objectives and policies of the comprehensive plan and the development patterns in the area. Any subsequent development at the site shall be required to apply for a new permit through Building and Development Services in Public Works, so we recommend approval. And before I step aside, I'd like to mention that we received 2 calls on this site. One was from Gail Burnham, and I think she's here to possibly speak today. And I received a call over the phone from Deborah Elston. She's at 1015 49th Street East. She's not able to attend. She may be watching. And that concludes the presentation. I'll stand by for any of your questions.
Very good. Thank you very much. You had mentioned the coastal planning area and the support with regard to this particular application. The focus was on removing mobile homes from the
That's correct,
CPA?
Mr. Chairman, yes. That is mandated in the comp plan.
Mandated, okay, so
Yes.
even though it was previously zoned, it would have been problematic to try to get an application?
Well, it was
approved?
zoned previous to our comp plan.
Okay.
So it was under the old zoning classification. It just got converted with the new code in 90, and they just, when they came in with those subsequent developments 25 and 20 years ago, they just held that same zoning classification of mobile home.
Right, and with the proposed zoning, the maximum allowable density per acre would be 9.
Correct.
I guess the form of the multifamily, there's a list of potential minimum yard lot sizes. I guess it's really not a lot. It could be something other than a lot. It could be a lot or something different. It would be incumbent on the applicant to do the math to make it work. For example, if you try to do lots, mathematically it doesn't work to 9 units to the acre, but
Absolutely.
it's not an authorization to get 9. They still have to make it fit within the site and make it fit in accordance with the land development code rules and regulations is kind of the question I'm asking. Is that accurate?
That's correct. And by looking at the previous unsuccessful plans that were attempted at this site, even with the lots that were proposed, they were nowhere near the maximum density. There are some environmental, may speak to some of the environmental constraints that are at this site. I know we can't talk about that because we don't have a plan at this point, but those were some hurdles at the last 2 applications that came in. And Tom might talk about some issues with drainage too that goes on at the site. So although they're asking for 9, I think that would apply more to a multifamily type component where they would be going up rather than out.
Right. I think probably the takeaway from this line of question and answer is that even though the zoning would potentially allow it, the applicant still has the burden of creating a site plan that's consistent and something that fits within the site, accommodating any environmental features or anything associated with that. It's not granting them 9 units to the acre absolutely without consideration of what would be the mechanism to get to that yield.
That's correct, and we discussed that in those mitigating measures where this 9 units per acre allows that clustering to bring the development in, probably away from the surrounding properties if they desire to get closer to that maximum density.
Right, and just in your presentation, you did mention septic on neighboring properties. That was just a piece of information associated with the neighbors. I just want to make sure that there was no consideration or contemplation that septic would be allowed, septic systems, sanitary septic systems would be allowed on a new project under this.
It depends. If they were developed as single-family lots, they sure would be allowed. But under, obviously, multifamily, there would have to be extension or some sort of package plan of some sort. But it could still be septic if it meets the state requirements for septic tank and leach line.
Right, and I think your answer has an important point there. It has to be appropriate under the state rules and regulations.
Yes, sir.
So, all right. And then another question, in your presentation, you showed Experimental Road. My general question, I don't know if it's for Tom or Mr. Galliano, that roadway seemed to be a substandard roadway section. Is there concern with regard to authorizing a change in density on a property that would potentially be putting more trips on Experimental Road?
Nelson Galliano, Transportation Planning. Experimental Road should be get the county standards to be functional.
It's currently at?
Should be.
Okay. I'm sorry, what was that?
Mr. Chair, if you don't mind.
Yes.
For the record, Thomas Gerstenberger, Public Works Department, have been sworn. What Nelson was alluding to was if the county does not presently meet county standards with respect to travel lane width, then the road would need to be brought up to county standards. In addition, should there be any requirements per se from a traffic study, then operational improvements may be necessary at any proposed entrances into this project.
Okay. All right, that's kind of what I was trying to get. The ability to actually develop this property might come with some contingencies related to the improvement of the section, the roadway section. So that is
correct.
Okay, all right, that's what I was trying to get to. Sorry, might have been a convoluted way to ask the question. So, any additional questions for staff? Mr. Smock.
I'm still hung up on the sewage issue. I mean, what kind of sewage availability does Manatee County have if they try and attempt to go for anything greater than a 2 or 3 unit per acre, allotting for drain field and septic? Because otherwise they're going to have a force main system pumping it somewhere to make that allow. And so where would they be able to access that?
I would ask the applicant. They have had meetings with Public Works about this issue, so I'd invite Mr. Foley to comment on that.
Right, we'll get some input from the applicant, but just in general with regard to development, the counties cannot restrict the use of septic systems. Is that correct?
It's correct.
But the county defers to the state with regard to the feasibility and ability to do those?
There is a process where they, and maybe Tom can expand on this, about having to prove the ability to tap in. Mm-hmm. So until that's done, they are not obligated to tap into county sewer.
Okay, very good. Thank you. Thank you. Mr. Smock, does that?
Yeah, there has to be a serious consideration before we're talking about 9 units per acre.
Right. Yeah, so
there's no drain fields going to be allowing for that.
Right. Very good. Thank you. Mr. Gerstenberger.
Mr. Chair, if we have the overhead camera, please. Let's see if I can bring this up right. And let me focus over here in the western portion of this particular map exhibit. The rezone property in question. Good boy. Got it, guys?
Okay. Need a long stick.
Yeah. The rezone property in question is outlined here in yellow, and the closest proximity to an existing gravity sewer system is over here to the west of the project and also to the west of the railroad crossing on Experimental Farm Road. And I believe the engineer of record had already brought this matter up during his opening comments, but as far as any connection to the existing sewer system, that would require that extension along Experimental Farm Road. In this particular case, should the extension be to the west, would require some form of either directional drilling or jack and bore drilling underneath the railroad crossing to connect to that existing gravity sewer system along Experimental Farm Road itself. And while I'm up, I thought I'd also touch on the subject of drainage and flooding, considering Mr. Rigo had already brought it up during his comments as well. First map exhibit, again, is of the rezone application area. One thing that's missing from this map exhibit is floodplain delineation. This map exhibit happens to be of the FEMA 2014 effective firm flood insurance rate maps. What you see missing from this map is any 100-year floodplain delineation. However, if we turn our attention to this new map exhibit that I brought up, which happens to be the 25-year floodplain delineation that is available from the county, from a county 25-year floodplain study that was done back in 1998. The blue line is identifying those areas that happen to be in the 25-year floodplain. Let me take a moment to point those out a little better. So what you see on site, essentially in this area here that I'm tracing out with the pen, are those areas of this particular property that are subject to 25-year inundation from a 25-year storm event. Staff has requested, as part of review of this rezone application, that any subsequent final site plan or construction plans that are submitted for development of this property, that the engineer calculate the 100-year flood stages associated with this property, and to further delineate a 100-year floodplain for the subject property that would also be subject to floodplain mitigation as part of the final site plan construction plan review. At this time, I'd be happy to address any further questions that the commission may have.
Thank you, Mr. Gerstenberger. Is the 1998 flood study, is that the best available information for this area?
Mr. Chair, you would be correct, unfortunately. The county actually has a cooperative funding initiative application that soon, cross fingers, but is pretty likely, will be proceeding forward with Southwest Florida Water Management District and proceeding as a water management plan for this particular area of the county. That would include this particular drainage system, which happens to be the Tampa Gap drain.
And then have you looked at the information from FEMA? Is that information dated also?
The unfortunate fact is that is the data from FEMA.
Oh, okay.
Which identifies no 100-year floodplain. The nearest 100-year floodplain that is identified on this particular system is to the west of US 41. Obviously, as part of our efforts with the cooperative funding initiative for that watershed management plan, would be to further refine drainage modeling and subsequent 100-year floodplain delineation within this particular area.
Very good. Thank you. Any additional questions for staff? Okay. Mr. Rutledge?
No, none. Thank you, Chairman.
Thank you. All right. We're going to go ahead and open up the application for public comment. I have one speaker card. I'll call Ms. Gail Burnham up, and you'll have 3 minutes to make a statement or ask questions, raise your concerns. And if you would, please state your name and that you have been sworn. And after Ms. Burnham, we're going to open it up to anybody else who wishes to come forward. So good morning.
Good morning. I have been sworn.
Thank you.
My address is 1013 49th Street East. There are several issues I have with this. Rush hour traffic being the main one. All of this stuff doesn't address rush hour traffic. I live there and I deal with it. I have one exit from my property, and that's onto Experimental Farm Road. My other problem is nobody's talking about the police station and the EMTs that are right next door. They didn't even show a picture of it. I think they're very, very important. These people's job is to get somewhere as fast as possible to help you when you have an emergency. And if this road is clogged up, they cannot do that. These trucks can't go off the road. And most of the places, the cars can't go off the road. One place, the ditch was referenced. You don't want to go in that ditch to help the firemen out. So these, to me, are very important issues. I bought this property and I bought the pasture behind me so that I wouldn't have somebody build a neighborhood right next to my back fence. And now I'm faced with somebody putting possibly 648 people that I could walk to their house. And during rush hour traffic, 648 cars coming out of there. They at minimum need to go out onto 41 but it's showing them going out onto Canal or 49th Street East. These roads are not intended for this kind of traffic, and they should not have to deal with it. I personally don't want to put up with somebody boring under the railroad track right outside my driveway to get a sewer system to this development. That would be very inconvenient. It might improve the mess that's at the railroad track that's causing a lot of problems with vehicles, but it wouldn't be very comfortable for me. Debbie is my next door neighbor. She's the other lady that called Mr. Rigo. Very inconvenient, all of this. And I just think you need to think about the firemen and the EMTs who go by my drive all the time. I can hear the truck, the fire truck, because that massive engine has a huge sound. They're busy all the time, and they don't need this aggravation. Thank you.
Thank you. Again, is there anybody else who wishes to come forward and speak on this application? Anyone at all? Good morning. If you could, please state your name and that you have been sworn after it's cleaned, I guess.
Hello, my name's Howard Keever. I live at 1013 Experimental Farm Road.
And you have been sworn?
Have
you been sworn in?
What's that?
Have you been sworn in? Did you swear in?
I swore.
Okay, thank you.
I was extremely disappointed that we were not notified, like some of the rest of our neighbors, that this was happening, and also that the posted signs out on Experimental Farm Road as of this morning were non-existent. One's been down for several days, and the other one was gone this morning too. It seems like there's a 325 units on a septic system would be extremely stupid. You'd need that much property to run the septic system, much less apartments. You're throwing a 325 units, which are probably 400 to 600 cars, onto a property that most of it's going to come on Experimental Farm Road because there's no traffic light on 41 to access getting in and out. And because of the fire station right there, it's going to restrict their emergency response. And and at the end of Experimental Farm Road is a new development which is not filled in yet, which is going to add immense amount of traffic on that road. Not only with this add more traffic, but as that adds more traffic too, it would be just a hellacious thing trying to get out of the driveway on the road with all that traffic coming down there. That new development is on Ellington Gillette, but it funnels right into Experimental Farm Road. That's my protest. Thank you.
Very good. Thank you. Again, is there anybody else who wishes to come forward and make a comment or statement? Come on up. And again, if you would, please state your name and that you have been sworn.
My name is Andrew Kane, and yes, I have been sworn in. I own a 5-acre parcel along Canal Road that would basically borders this project, and I'm concerned with how it changes the runoff of the properties that are adjacent to this. if they are to do a development there and bring in fill dirt and change the way that the water flows naturally at this point, how's it going to affect other properties that are adjacent to it with flooding and runoff? And like the other people have stated here, the amount of traffic that's going to go along what are small country roads at this point. How's that going to affect people getting in and out of their driveways safely, and the breakdown of the existing roads that are there that weren't meant to handle this kind of traffic or load? They're all bordered by ditches. There's no curbing. My other concern would be, yes, if they do a jack and bore and they are doing sewer ejection system for that property, is the gravity drain that they're going to tie into, is that rated for that kind of extra flow? Or are they going to run into an additional problem with backup? And if there's a contamination in the area with a sewer overflow, who's going to handle the cleanup on that? Is there going to be a fund set aside? These are some of my concerns.
Very good. Thank you.
Thank you.
And again, anybody else wishing to come forward and provide any comment or ask any questions regarding this application? Anyone at all? All right, seeing no one else come forward, we're going to go ahead and close the public comment portion of the hearing and just open it up for some discussion, and then we'll go to staff closing comments and rebuttal and call it to the vote. But first, Mr. Foley, can you answer a few questions that came up through the staff presentation and some comments that were raised by some of the neighbors?
Yes, I'll be happy to. Let's talk about the sewer first.
Mm-hmm.
There were two options we discussed with the county. One was the option that Tom Gerstenberger identified for you, which was going to the west underneath the railroad track, tying into the gravity system along US 41. The second, though, was to go east down Experimental Farm Road to 28th and tie into the existing county sewer system there. In either system, whether we go east or west, I'm sure once the sewer line leaves the site, it will be dedicated to Manatee County. It will be part of the Manatee County system, which is maintained by Manatee County. We have verified that there's capacity going both east and west, so we're not worried about an overflow blockage. We're not worried about ongoing maintenance issues on Experimental Farm. This will be a typical sewer system dedicated to the county for maintenance off-site. I'm sure on-site will be a matter to be discussed later on. Second, regarding traffic, Ellington Gillette Experimental Farm Road is not a 24-foot curb and gutter roadway section, unfortunately. But as county staff has said, at the time that we do our development plans, county will look at any needed access improvements to the intersections and address any other issues that might be needed for this project to receive approval. The appropriate time to talk about any specifics regarding access, turn lanes, things of that sort will be when this project comes back to you in a final site plan.
So at this point, you're not seeking anything related to concurrency for traffic?
No, sir.
And then it's not really relevant to the application, but I think it may be something that would be worth noting. Has there been any discussion with DOT regarding access to State Road 41?
There has not, and to be honest with you, that's probably not something that the DOT would even entertain.
Right. In your professional opinion, what would be their reason for not allowing that?
If you were to be on 41 looking at the site, you will see that it's not at grade. And I think that would be the biggest issue. But, you know, I think, you know, the intention would be to use at least 2 points of access on this site, as pointed out in the overhead aerials. The site has frontage on experimental Farm Road, but it also has a strip access to Canal Road, and I think the prudent thing to do would be to try to use both access points.
Is it your understanding that developments that have more than 100 units would require 2 points of access?
Yes.
And then with regard, just circling back to the sanitary sewer system, just to, again, close the gap on the discussion. Previously, there was some discussion that the county cannot prohibit septic systems if the state would allow them. Has there been any discussion, or what led you to the conclusion that you would have to extend county sewer to serve a potential project on the site?
Well, there are 2 or 3 things you need to look at, and I'm not an expert on septic tanks. Fortunately, being in Manatee County, that's not something that we have to deal with a lot, because we do have a fairly extensive sewage collection system in the county. But if you're in unincorporated county or outside the county service limits where you're in a system that uses a septic tank, you've got groundwater issues to deal with. Tom has mentioned that quite a bit of the sites in the 25-year floodplain. Those septic tank systems to function have to be elevated above that to work. So you have mounding issues. Second thing is the septic tanks systems. I think there's a minimum drain field, and I can't remember the size, Bill, but I want to say it's is it 750 square feet? I can't remember exactly, but the real deal is a mobile home zoning using septic tank. That would not be something that you'd be able to see function here.
So is it fair to say that was considered and disregarded as an
that was disregarded with every project that's come before you on this piece of property. There's the other 2 plans that were both approved by the county. Neither showed septic tanks being used. There was always a tie to county sewer proposed.
Very good, thank you. And then the last question I have is regarding the drainage basin and the floodplain. Generally speaking, what is the approach with regard to the floodplain that's been represented on the project? What would the design intent be with regard to that?
Well, we're seeing more and more of the county being mapped in the 25 and the 100-year floodplain as more sophisticated models get developed. Being inside a county 25-year floodplain or being inside a county 100-year floodplain doesn't preclude development. You just have to meet the development standards in play. And, of course, the deal here would be to create some sort of floodplain compensation area. Typically, that would be a stormwater pond or a designated floodplain compensation area, where basically you're doing some sort of cut and fill, cup for cup analysis of creating storage below the 100-year floodplain in areas that you're not developing to compensate for areas that you are developing that would be in the 100-year floodplain.
In addition to the floodplain compensation area, the intent would be to do stormwater ponds for the typical treatment and attenuation.
Correct, and the county has very stringent guidelines for meeting pre- and post-development flood flows. But also what Tom was alluding to is we're going to have to do an analysis to show that we're not expanding or increasing the elevation off-site of the 100-year floodplain. So there'll be both the typical county requirement for meeting pre and post storm attenuation requirements, but also there'll be the added requirement to make sure we're not impacting the 100-year floodplain, 100-year flood elevation.
And that's what's typically referred to as the pre versus post condition, where you have no adverse impact on the neighboring properties. You try to meet that. Is that correct? Okay. And then following up with regard to the floodplain, tying it back to the other infrastructure, I think Mr. Rigo's presentation, he made a comment regarding the fact that this is within the coastal planning area, that infrastructure is a consideration, the design of infrastructure is a consideration. How would you propose to accommodate the requirements that this be in the coastal planning area?
Having not done a plan, all I can tell you that my caution would be, if you look at that coastal high hazard area, it only encompasses a small portion of the site. And basically my advice to any client would be to stay out of it.
Okay. So avoidance would be your response to that question.
Correct.
So, okay, very good. Thank you. Any additional questions for the applicant? Mr. DeLesline.
Yeah, what type of development are y'all leaning towards right now?
I have no I've been provided no plan.
So typical on applications that are straight zonings, it's always good to know. It's information that everybody would like to know, but it's not required for.
We did some testing with smaller lots. We did some testings with attached townhomes, but there's nothing that's been. Here's what we're going to move forward with.
So there have been no preparation or no application submittal that depend on the zoning to move forward. It's
Correct.
Just strictly a rezone at this point.
Correct.
Okay.
Now, this would be for staff. Would it come back towards us on final site, or would that be administrative?
It's my understanding, if it's consistent with the zoning, that it would be an administrative review. Is that correct, Mr. Rigo? Very good. Thank you. And Mr. Rigo replied in the affirmative for the record.
Yes, sir.
Okay, thank you. Very good. Any additional questions for Mr. Foley? Mr. Roth?
Well, actually, not for Mr. Foley. Is this on?
Nope. Just try again.
Can you hear me now? No.
Hold on, he's Can you hear me now?
I think I can speak loud enough so you can hear me. In terms of the floodplain that currently exists.
We have to get you on the mic.
Okay. I'm good.
I think he's good.
I think I'm good. Now it's really green. Okay. In terms of the current floodplain, if someone's standing on that property now, is there evidence of flood during a normal rainstorm?
Mr. Chair, Commissioner Roth, I would venture to say the answer is yes, especially given this time of year and especially after with the existing floodplain delineation that's in place for a 25-year storm at that particular storm event, which would be equivalent to 8 inches of rainfall within a 24-hour period. Yes, you would expect to witness or to see areas of inundation associated with this project area, with this parcel itself. And in addition, there are areas of this parcel that have been identified by SWIFMUD as jurisdictional wetland areas.
Mm-hmm. In order to mitigate for that problem, it's obvious they're not going to get 327 units on that property. Would that be fair to ask anyone?
Commissioner Roth, obviously without a site plan, it's hard to tell for certain, but certainly there are certain engineering provisions that have to be accounted for as part of the design of any particular project associated with this property, whether it is stormwater, whether it is floodplain mitigation, whether it is avoidance of the jurisdictional wetland areas, access requirements, whether they be the access points out onto Experimental Farm Road or internally as far as either public or private roadways or driveways. Parking obviously would be a concern as well as far as the parking demands that would be required for, say, like an apartment complex, or if it is attached multifamily product, the parking that is required per unit. So yes, there are certainly a number of factors that go into the design that make the final determination as to what number of units can be built on this particular property.
Okay. I have a question regarding roadways. Both Experimental Farm Road and Canal, would you say level of service is D? I think it is D.
Nelson Galeano, Transportation Planning. Based on the traffic study, the level of service of Canal Road and Experimental Farm Road is C.
C, okay. Next question. Is there, or where is on US 41, where it meets Experimental Road, is there a traffic light there currently?
Yes.
North on Canal Road, where it crosses 41, is there a traffic light there?
No, not yet. Okay. Probably due to this development, they need to go to FDOT and AXI-5.
And have to apply to FDOT.
Yes.
Okay, thank you.
Very good. Any additional questions for staff or the applicant?
Mr. Chairman?
Who said that? Oh, Mr. Rutledge.
Bill, I'm starting to get a complex.
Who said that?
All right, who said I had just 2 points. As I understand it, we're converting a significantly older zoning template that's on this property to what is the more contemporary model. And as a part of that, it has to then be reviewed by staff for meeting all the compliance with the issues of road, sewer, density, and all the services. So I just as much as I may imagine what might go there, I think the idea of moving it into contemporary zoning with what we need and with the constraints that we have, I'm not sure I follow all the discussions about what might happen, what could happen, and so forth. We'll have staff review, and that opportunity would then give us a clear kind of perspective on what those questions are. Am I misreading the request?
Not that I can ascertain, but if there are no other questions for staff, let me make sure there's no other questions for staff for the applicant. Okay, all right, we're gonna go ahead and actually we need to go through, before we go to deliberation, we need to go to staff closing comments. Any staff closing comments?
Mr. Chairman, no. I think Mr. Foley's answered my concerns.
Very good. And Mr. Foley, any rebuttal or closing comments?
No, sir. I believe it's been summed up very well. Thank you.
Very good. Thank you. And what I'm trying to do is get to deliberation and discussion. So I'm going to close the portion of the hearing where we provide testimony and open it up for discussion and deliberation. And Mr. Rutledge, I agree with your interpretation of what's being done. The fact that the zoning would authorize a specific number of units is by no guarantee that those units could actually physically be constructed. If, Mr. Roth, you brought up floodplain, if by chance the entire site is floodplain and they have to accommodate it within the rules and regulation and they only get to build one unit, I have a feeling they're not going to move forward with the project. So they have to work within the framework of the rules and regulations. Just because zoning says you can have something, there is nothing that dictates that's what you're going to get. In many cases, zoning is a conceptual or theoretical maximum the reality, and many times is a stark reality. It's very different than what, and I think the applicant has mentioned that this has been evaluated and considered many times, and I have a feeling that might be some of the constraints that have caused it to not move forward. There may be something that somebody can come in and find something that works well and fits within the framework of the constraints of the property based on traffic, sewer, and things like that, floodplain, stormwater issues. But our process is to consider if it's consistent with the comprehensive plan and the land development code. In this case, there's very little information with regard to what it could be. We're just looking at the kind of the broader zoning categories. So again, trying to contemplate or guess what's going to be there is problematic with regard to what we've been asked to do. So just keep that as a consideration when making a decision. But other thoughts?
Well, height-wise, they can get up to 4 stories.
Right.
So it could be a multiple.
On your mic.
Oh, height-wise, they can get up to 4 stories on this.
Right. And again, the form is unknown at this point. Yeah, I doubt that if Mr. Foley has indicated that he has no clear knowledge of what could be there, I presume that would still be allowed or it's allowed under the zoning, so it could be a consideration. So absolutely. Anything further? Mr. Rutledge?
I would only finally say that I think we've progressed since 1988. Perhaps Zoom is an example, but I just do think that getting these under the contemporary model of what we want to do and what developments come to, a 20 or 30-year leap in what the standards are good. I think we do a good job with our staff. I am certain Mr. Gerstenberger will not permit them to fail to address the flooding, the wetlands, and so forth. So I'm confident there, as with the rest of the staff on traffic. So I think this is our code. They're allowed to make them contemporary, and I'm not opposed to that. I don't like not knowing what's going to happen, but I also am not afraid to let people step into the design we've already prepared and been well serviced by for the stuff that's been developed. So I'm going to be very supportive.
Very good. Thank you. Anything further?
Call the vote.
Okay. Chair will consider a motion. Anyone?
Mr. Chair, I recommend denial of Manatee County zoning ordinance number Z2002.
Very good. We have a motion to deny.
Mr. Chair?
Yes, ma'am.
You want me to fine-tune how you would format that motion?
Yes, please. Yes, please.
It would be based on the staff report, evidence presented, comments made at the public hearing, find the request to be inconsistent with the Manatee County Council Plan and the Manatee County Land Development Code. I move to recommend denial of Manatee County zoning ordinance Z2002 as recommended by staff.
We have a motion to deny. Is there a second?
I'll second for discussion.
Okay, Mr. Smock, second, and then opening for discussion.
What's the reason for the denial?
Well, a 4-story rental or something wouldn't go in that neighborhood. I just don't think it's consistent in that rural area.
But we don't know what they would build.
No, we don't.
I mean, currently as a mobile home zoning, they're very limited in what they could do. So changing the zoning allows them a little more flexibility.
So, Mr. DeLezine, your main point of contention would be the height, or
I think if they came back with a site plan with the zoning change, I would probably recommend it. But as of right now, not knowing what could go there.
Mm-hmm.
So, Mr. Chair, just for the record, that comment would go to 342.3A of the Land Development Code. A says compatibility with existing development pattern and the zoning of nearby properties. I think height goes compatibility. Just wanted to state.
Okay. So very, very good. Thank you, Ms. Schenk. That's oftentimes compatibility is the hardest thing to nail down. So it would be the compatibility with regard to the surrounding neighborhood.
Yes,
okay.
sir.
Okay, any additional discussion, deliberation, opinions before I call the matter to vote? Okay, hearing nothing further, I'm going to call the matter to vote. I'm going to do a roll call as I did previously. So again, the motion is to deny. So Mr. Roth? Nay. Nay. Mr. Smock?
Nay.
Mr. Heap?
Nay.
Mr. DeLesline?
Aye.
Aye. Mr. Rutledge?
Nay.
Nay. The point is moot, but chair would vote nay also. All right, the motion failed for lack of support, so the chair will consider another motion.
I would move to accept this recommendation of the staff, and perhaps council can word that for me.
As written?
As written.
You want me to read
That you move the recommended motion in the agenda memo.
Yes, ma'am.
All right, we have a motion by Mr. Rutledge. Do we have a second?
Second.
Mr. Ross, second. All right, we're going to call the matter to vote. Any discussion or deliberation? All right, we'll call the matter to vote. Mr. Roth?
Aye.
Aye. Mr. Smock?
Aye.
Aye. Mr. Heap?
Aye.
Aye. Mr. DeLesline?
Nay.
Very good. Mr. Rutledge?
Aye.
Aye. Chair votes aye. So motion passes 5-1, and Mr. DeLesline's dissenting vote is, I think, well documented. Yep. Thank you. Very good. Thank you. Motion passes 5-1 with Mr. Ron being absent. So, all right. Thank you. That concludes item number 4. We're going to move on to item number 5. Ms. Lydar, can you please read item number 5 into the record?
Item number 5, C-2004, Nixon's rezone to HC, Nixon Fruit Farms, ENC, owner, Gray K, LLC, former known as Hunt Real Estate Services, ENC is the contract purchase. It's a rezone of approximately 4.36 acres generally located at the southeast corner of the intersection of 26th Avenue East and 27th Street East, and commonly known as 2712 26th Avenue East, Bradenton, Manatee County, from agriculture suburban A-1 to the heavy commercial HC zoning district. The case manager is Mr. Jake Bibler, and here representing the applicant is Ms. Marla Hogg.
Very good, thank you. And again, this is quasi.
Yes, it's a quasi-judicial
It requires sworn testimony, so thank you very much. Good morning, Ms. Huff. How are you?
Good morning. I'm Marla Huff of Huff Engineering, Inc., and I've been sworn.
Thank you.
Also with me here today are Kevin McCraw and Hamilton Hunt Jr. of Hunt Real Estate Services, Inc. Natalie, can you please show photo 1? We are requesting to rezone 4.43 acres on the southeast corner of 27th Street East and 26th Avenue East. The property is currently an agricultural use with citrus and is owned by the Mixons. We are proposing to rezone from A1 agricultural to HC heavy commercial. The future land use is IL industrial light, which is compatible with the proposed heavy commercial zoning. Please move to photo 2. You can see the neighboring uses from the aerial photograph. Specifically, 26th Avenue East contains a collection of school bus uses, agricultural, mobile home park, and warehouse distribution. 27th Street East uses include mobile home parks and single-family residential subdivisions. A rezone to heavy commercial will be compatible with existing development patterns since the site is located adjacent to 2 urban corridor roadways listed on Manatee County's transportation link sheet. This is an infill site that will serve the residents, passing traffic, and neighboring properties. Natalie, please move to photo 3 and then quickly move on to photo 4. The adjacent uses immediately contiguous to the site are the school's Matsky Support Center to the south and to the west, with a zoning of BRI, which is City of Bradenton Industrial Zoning. Please move to photo 5. All the other surrounding land uses are separated by roadways and include north across 26 is Mixon's Market, where you can purchase everything orange, including orange ice cream. Move to the next photo. To the west, northwest across 27th Street East is Glen Creek Residential Subdivision. Move to the next photo. West across 27th Street East is agricultural property. The site does not have any wetlands and is located outside of the 100-year floodplain. A traffic impact statement was prepared for the site and approved, but as is typical, concurrency cannot be obtained until the preliminary site plan, final site plan process. The parcel is currently served with potable water and central sanitary sewer. The county is in the process of developing improvement plans to 26th Avenue East. We have worked closely with them during their 30% complete stage of the plans by having a teleconference with their transportation staff and project manager to tweak the plans to ensure compatibility between our site and their improvement plans. I would be happy to answer any questions you may have.
Very good. Any questions for the applicant?
Yes, sir.
I have a question for you. You're proposing a rezone to heavy commercial, yet the traffic statement provided says 7-Eleven. Is the traffic impact statement a correct document in here?
That's a possible use for it, but it is a straight rezone.
Okay. All right. I just, in my mind, there seems to be a little bit of a disconnect between heavy commercial, heavy commercial and what was represented in the traffic impact statements. I'm just making sure that that's accurate. The documents you provided were meant to be part of the application.
And if it were to be a 7-Eleven, that is allowed in the HC zoning, but they try to keep us on these Euclidean rezones not to name names.
Right. And
so I guess that got overlooked. It got missed. It should have just been more generic.
Yes. So with regard to the purpose, what we're typically see a traffic impact statement, the information provided is consistent with the requested zoning. Correct?
Yes.
Okay. All right. Very good. Thank you. All right. Any questions for the applicant?
Yes, sir.
Very good. Thank you very much. Mr. Bibler.
Good morning, Jake Bibler, planner for Manatee County Building and Development Services, and I have been sworn. We have a slideshow presentation. This is the Mixon rezone to heavy commercial, and just to note, this was formerly known as the Mixon rezone 7-Eleven. That's was initially submitted under that name, and we asked them to change to heavy commercial as a matter of the Euclidean zoning. That's where the 7-Eleven emphasis on the traffic impact statement came in. This is a request to rezone from suburban 4.36 acres from agriculture suburban to heavy commercial. The general location is at the southeast corner of 26th Avenue and 26th Street East, 1.3 miles approximately south of Manatee Avenue. The current use is a citrus grove. Property is owned by Mixon Fruit Farm. The future land use is IL. The IL future land use district industrial light is intended to identify areas with a range of light industrial and other employment-oriented uses, in addition to intensive commercial development, which would have significant adverse impacts if located adjacent to residential areas. Also included in the future land use category, the potential zoning districts are light manufacturing, heavy commercial, neighborhood commercial small, and neighborhood commercial medium are subject to commercial locational criteria, and industrial, and conservation. As a note, general commercial is not an allowed zoning district in the industrial light future land use category. The current zoning is suburban agricultural, as mentioned, and the request is to rezone to heavy commercial. The heavy commercial zoning district is intended to provide areas for intense commercial activities, permitting commercial and service uses which have greater external effects such as noise, traffic, vibration, outdoor storage, and other such impacts than those permitted in the less intensive districts. We do find that the request to move to heavy commercial is consistent with the land development or the comprehensive plan category. Mouse is a little touchy. Positive aspects are this is an infill site at an intersection of two collector roadways. The site is served by county water and sewer. It has easy access to major thoroughfares, and the project site is adjacent to other industrial and institutional areas. As Ms. Huffin pointed out, the uses to the south and to the east are the Matsky Service Center. The property to the west, and I'll go back just so you can see the aerial here. The property immediately to the west is vacant agricultural land, but it is in the city industrial zoning district. And speaking to the City of Bradenton Planning Department, they do intend for this to eventually be developed in a commercial capacity. Negative aspects are an increased potential for light and noise to the surrounding area and a potential for increased traffic. The mitigated measures are the Land Development Code provides standards for specific uses that may have negative externalities. Mitigation measures will be administratively reviewed at the time of final site plan, and there are planned improvements to this intersection. Staff recommends approval, and I'm available for questions.
Very good. Any questions for staff?
Yes, sir.
All right. Hearing none, we're going to go ahead and, yes, Mr. Gerstenberger.
One quick point of clarification.
Please.
The applicant had brought up that the project is not within a 100-year floodplain. That is correct pursuant to the 2014 effective flood insurance rate maps for this particular area. However, there is a watershed management plan that has been performed by the City of Bradenton and Southwest Florida Water Management District, and there is 100-year floodplain delineation based upon that watershed management plan for this particular property. I can illustrate that with the map if you would like.
I don't know that it's necessary, but I do have a question related to that with regard to how it would affect this application. Is the county accepting that information as the best available data?
Yes, we are.
So that would be the information that the county would require with regard to any proposed design.
Correct. Yes.
Is that information also being submitted to FEMA? Is that what's being utilized to?
I don't believe so because it is outside of the jurisdictional limits of the city. Mm-hmm. However, the county, as unfortunately, same case again, as was brought up with the prior application and again with this application, the county is beginning a watershed management plan through a cooperative funding initiatives with Southwest Florida Water Management District that would include this particular area as it does drain into Glen Creek, Sugar House Creek watersheds.
Okay. All right. Very good. I think those things usually take quite a few years, but
Yes.
relying on best available information is always a expectation with regard to the engineering practice, so thank you.
Certainly.
Any additional questions for staff? All right, we're going to go ahead and close the staff portion of the presentation, and we're going to go ahead and open the public comment portion of the hearing. So I would ask if there's anybody in the audience who wishes to come forward and speak on this application, please do so. Anyone at all? Okay, seeing no one come forward, we're going to close the public comment portion of the hearing, and I guess ask staff, are there any closing comments, anything additional?
Mr. Chair?
Yes, ma'am.
I just wanted to note the record, there's a school report.
Oh.
And they're noting some adverse impact concerns. Can staff provide testimony about the code, how we address adverse impacts for non-residential uses? There's a code section that speaks to it, and someone needs to testify about it.
Jake Bibler for staff. Amy Anderson, I believe, is in the audience, so if we have any questions for her regarding her report, then I believe we can ask those. The Land Development Code goes through a specific list of use criteria and reviews for certain aspects and development in regard to any development. I believe, Sarah, did you have another?
Well, I meant there's discussion here about dust, vibration, noise, and I know there's a code section concerning it.
Yeah, at time of final site plan, the applicant shall to demonstrate that they comply with all the regulations of the Land Development Code regarding impacts under the section 542. And this is depending of the type of facility that will be proposed, going to be required the analysis of all the items that are listed in the Land Development Code.
So the concerns of the school board, it would be incumbent on the applicant to address those at the time of final site plan? Is that correct?
Yes, it's correct. At
Okay.
final site plan, depending of the specific use that will be proposed, we're going to require to address all the section of the code. And with the rezone general zoning district, the applicant shall comply with all the regulation of the Land Development Code.
Right.
Additionally, the school district is one of the reviewers when it comes to final site plan review, and they do provide comments in regard to final site plans as well.
Very good, and of course, this is written presuming it's approved for heavy commercial without a specific use. So I think many of these things may be addressed just identifying the type of proposed use. So very good. Thank you. Thank you, Ms. Shank. Thank you for that clarification. That got lost in between traffic and the affidavit. So thank you. All right. Any additional questions for staff?
Yes, sir.
Very good. All right, applicant, closing comments? Lost you, there you are.
Thank you, Bill. Marla Huff. The only thing I'd like to say is we did respond to the school comments in the rezone in detail with our resubmittal on March 23rd. And of course, we look forward to making sure we comply with the code in the final site plan process.
Very good, thank you. All right, we're going to go ahead and close the public, the testimony portion of the hearing and open it up for discussion, deliberation, or considering a motion. I would like to state, similar to the previous application, I think compatibility is a bit of a question. This area, one of the difficulties in this area is it's such an eclectic collection of different uses. So I know this area very well. My great-grandparents lived in this area, so I've been going to this area for over 50 years. And It's I've seen it change quite a bit through the years, but there are so many different types of uses, including the I think the pirate facility to the north, and of course the school board facilities. Has a huge impact on this area, but it's so many different things going on. It's hard to say that there's something's not compatible, especially when we don't know what it is. But so with that being said, any additional discussion, deliberation? If not, we'll consider a motion.
Mr. Chair?
Mr. Rutledge.
That's me.
Oh, I'm sorry. I looked up. He wasn't there.
I move recommend adoption of Manatee County zoning ordinance Z-2004 as recommended by staff.
Mr. DeLesline has made a motion. Is there a second?
Second.
Mr. Ross, second. Any additional discussion? All right, hearing none, we'll call the matter to vote. I'll do a call. Mr. Roth.
Aye.
Mr. Smock.
Aye.
Mr. Heap.
Aye.
Mr. DeLesline.
Aye.
Mr. Rutledge.
Aye.
Very good. And chair votes aye. Motion passes 6-0 with Mr. Ron being absent. So I believe that concludes our agenda today. Appreciate everybody putting effort toward this, and we're going to go ahead and close the meeting. Thank you very much.